In 2003, Chief Justice E. Norman Vesey wrote that split decisions by the Delaware Supreme Court, especially in the field of corporation law, are few and far between. He was right. In the almost 18 years since the novel landmark case of Smith versus Van Gorkum, there had been only one dissent in any corporate law opinion. But Chief Justice Vesey made this observation as part of one of those rare dissents. Along with Justice Myron Steele, he sharply disagreed with an opinion by Justices Randy Holland, Carolyn Berger, and Joseph Walsh that invalidated a merger of NCS Healthcare with Genesis Health Ventures that had been challenged by competing bidder Omnicare Incorporated. How did such a rare and stark conflict of judicial views come about, despite almost 20 dissent-free years of intense and rapid development of the law of fiduciary duties in mergers and acquisitions? We may never know the answer for sure, but we may get hints from several of the key participants in the Omnicare case. Litigators Ed Welch of Skadden Arps, who represented NCS, Dave McBride of Young, Conaway, Stargett and Taylor, and Ted Mervis of Wachtell, Lipton, Rosen and Katz, who represented Genesis, and Don Wolf of Potter, Anderson and Caroon, who represented Omnicare, two transactional advisors, Morton Pierce of White and Case, who represented Omnicare, and Mark Gordon of Wachtell, Lipton, who counseled Genesis, and two of the judges in the case, Vice Chancellor Stephen Lamb and Justice Myron Steele. Whatever might have explained the split on the Supreme Court, an explicit disagreement about the facts wasn't it, as Vice Chancellor Lamb, whose decision was reversed, noted.
In the preliminary injunction proceeding, in particular, the conduct of the board is the main focus. And so the conduct of the board over the long period of time in how they arrived at this particular transaction was important.
Absolutely, and it had quite the record, and the Supreme Court adopted all the findings that...
The Supreme Court just took all the findings, from my opinion, and incorporated them.
Yes, it did.
Those findings acknowledged the financial difficulties that the target company, NCS, was facing.
NCS was a failing company. It was insolvent, it was in bankruptcy. They were looking at a future in which the equity was going to get nothing. And the bondholders, the debt holders weren't even going to get, they were going to be made to sacrifice as well.
It was also widely acknowledged that Omnicare, under the leadership of its CEO Joel Gamunder, was an aggressive acquirer, the biggest player in its industry, and, in particular, a thorn in the side of Genesis.
So the industry dynamic was, and Omnicare really truly was the 800-pound gorilla bully of the industry. Everyone else in the industry was afraid of them. They were very aggressive in their business practices. I think it came out in the briefing that at one point, I think the year before, they had an aggressive business assault on NCS's business called the NCS Blitz, where they were trying to essentially put NCS out of business through their pricing and business practices. And they had made multiple kind of lowball offers to NCS. And then there had been a situation that you're describing where I think Genesis had been bidding for and was about to acquire another company in the industry. Again, I think this was 9 months to 12 months before, and Omnicare kind of came along at the last minute. They didn't want the company, they didn't want the target, they just didn't want it going to Genesis.
That history undoubtedly had a lot to do with the efforts by Genesis to lock up its merger with NCS as tightly as possible. Using a procedure authorized only 4 years earlier, NCS agreed to submit the Genesis merger deal to its stockholders, even if a deal came along later that the board thought was better. And the two NCS stockholders owning a majority of the voting power, John Outcalt and Kevin Shaw, agreed in advance to vote for the Genesis deal.
Well, our client viewed themselves as having sort of rescued this company and provided at least some payment to the equity holders, which every penny of which was a windfall compared to where they had been. So in return for that, we had an unusually, locked up, lock, stock, and barrel deal. which precluded any competition, any further competition, and made the vote kind of a silliness.
A foregone conclusion.
Yes.
Well, but the truth is there had been a lot of history and a lot of history with Omnicare and Genesis, which would support the fact that Genesis would say, I need some tough terms. I'm not going to be a stalking horse.
Right, I do remember learning afterwards, not in real time, that a lot of this was driven by the prior experience between Genesis and Omnicare in bidding for another company. And that's often, things like that I think are often lost sight of when you go back and look at these facts. I mean, CEOs and boards of directors are real live human beings. And if they've had experiences where they think they got the short end of the stick, driven by somebody else previously, they're going to try very hard not to be made a fool of again. And I think no doubt that drove a lot of the deal terms in this situation.
According to Vice Chancellor Lamb, NCS's own prior experience with Omnicare had been disconcerting as well.
Did the fact that prior to NCS's agreement with Genesis, the only offer that was being made by Omnicare was for sale out of bankruptcy, where the shareholders would get
Of course,
nothing?
I mean, eventually that got into the
Right,
briefs and got in
right.
front of me and was,
Change things.
of course, I mean, you have this bidder who never offered to pay even 100 cents on the dollar to the creditors. And this was
Right.
over a period of, now we are sort of getting to the punchline here, but in the preliminary injunction proceeding, it became obvious that both the NCS board had tried to negotiate over a long period of time with Omnicare, and also the creditors, this sort of informal creditors committee of Omnicare, they tried to negotiate. I don't mean of Omnicare, I mean with the creditors committee of NCS.
NCS.
They tried to negotiate a transaction with Omnicare at the end of the year before.
Correct.
And when they got to the point they thought they had a deal that they had negotiated with Mr. Gamunder, I think. And when the papers came from the lawyers, it wasn't the deal they thought they had. So they were put off by Omnicare.
The lawyers representing bidder Genesis could not overemphasize how determined Genesis was to walk away from NCS if its final merger proposal, with all its lockup features, were not accepted in full.
Here, I think Genesis would have really followed through because of their prior experience
Yes.
with Omnicare and because of the hostility. And I think I had the sense that they had been dealing with the creditor committee, they'd been dealing with the independent committee of the NCS board. They had made several offers. I think it was 4 or 5 offers before we finally got to the final offer. And I think they were just sort of fed up. Like, look, this is it. And we're not gonna, it's either now or never. And if you bring Omnicare into this thing, we're gone. Because in part, I think they just figured that it would be an endless quagmire if Omnicare got involved and they had to deal with Omnicare.
The seriousness of the Genesis take it or leave it ultimatum was backed up by the personality of George Hager, who became its CEO.
There came a point, I think, in June during the negotiations. It was a combination of we were concerned about our then CFO, but who was functioning almost as a COO or almost CEO, and who in fact to this day is the CEO of the kind of continuing company 16 years later, was very focused on this idea that if we are going to be in this situation and if we're going to sign up a deal, then we're going to get the deal. And he did not want to invest the effort or the time if this wasn't going to be successful for him. Our company was in good shape, but not in such incredible shape that they could afford the cost, time, and attention, and to have this not work out. So there was a lot of pressure from the client to try and come up with an approach that was going to be a guaranteed success.
Tell me about this this CFO acting
Yeah,
like
George
the
Hager.
right, because he ultimately made or told you to make an ultimatum that there was a 24-hour period to consider
So
a set of terms. Can you tell me
yeah,
a little
I mean,
bit
it's
about
very
that?
interesting because George is a very, very serious, high integrity person. Almost, I don't know if he served in the military, but almost kind of military bearing. And
Right.
very much in the camp of, or the school of, I say what I mean and I mean what I say.
Got it.
And not a lot of game. He's not a game player. And he says what he means, and he means what he say. If I make you a proposal, that's what I mean. I'm not trying to something else. And he was the one who was very concerned about if we go down the path of putting our credibility, our money, time, effort, all of it on the line, then I want to get this deal. The other thing, and maybe I can't tell if I'm jumping ahead on you or not.
No, it's
but,
fine. Go
one
ahead.
one of the key moments in the whole story is the weekend of July 26, 27, 2002, when. So on the night of the 26th, we extend our negotiating exclusivity with NCS for about 5 or 6 days.
Right.
That afternoon, Omnicare comes in with
Tender.
not yet with a tender offer, but they sent a letter saying that they would like to acquire. And
That's
the letter
right, yes.
The letter has conditionality in it.
Right.
And NCS comes to us and say, well, we have this, we're not sure what to do, and they used that to negotiate a better transaction out of Genesis. So Genesis increased its offer from the equivalent of $1 per share to $1.70.
Almost twice as much.
Oh, and also that's, I think, when we did the last bit of paying off all the creditors and
Right.
the trade creditors. But the trade-off for that was, Hager said to them, you have to accept this by Sunday night, Monday morning, or no deal. And he absolutely 100% meant it. Like, there's no doubt, there's not the slightest doubt in my mind to this day, then or to this day, that he meant it, and if they hadn't approved and we hadn't gotten the voting agreements, we would have walked and they would have been left to the mercy of Omnicare, and I don't think they ever would have gotten a deal with Omnicare. Because Omnicare had no real interest. Omnicare was just trying to keep it out of our hands.
The fact that Omnicare's nominally superior bid was conditioned on further due diligence left NCS with what it said was an unacceptable risk.
Well, Omnicare had taken due diligence of NCS previously. They had made several offers, none of which provided anything for the stockholders, but did provide stuff for the creditors.
debt, right.
And then they stopped negotiating with the NCS board and just started negotiating with the creditors committee. And so for them to come up after probably was a year, having made several offers, and having taken due diligence in connection with those, to say, oh, well, the offer we're making today is subject to due diligence, I was convinced it was a sham. I was convinced, not that they wouldn't do the offer, but that if we backed away, they would use due diligence as an excuse to drop their price or change their deal. So I thought the NCS's board's concern about whether if they didn't take our deal, Omnicare would stick with what they were offering was a very legitimate concern. And there were other things in the deposition of the Omnicare CEO, I can't remember now, that caused me to think that he was really manipulating the process.
Was his demeanor such that, did he come with an attitude or try to be evasive of you? Or?
I don't remember that. It was just that it seemed obvious to me that he was attempting to play the role of, I'm the savior for the stockholders, I'm the good guy here. And it was pretty obvious to me that that was a sham, that he had been trying to buy this company out of bankruptcy
on the cheap.
for years.
Right.
And for him to play this role of I'm the good guy was, and I just didn't think he was trustworthy.
Anyway, the conditionality of Omnicare's bid didn't impress Vice Chancellor Lamb.
In July, when the NCS board was in this series of meetings, and Genesis had made its last proposal, or it's maybe next to last, and Omnicare threw this thing over the transom, threw in a letter saying, we're
Right.
here. We want to pay your shareholders $3.50 a share in a merger, and we'll pay everybody. Right? When that happened, the NCS board was subject to this exclusive arrangement with
Right.
Genesis, so they couldn't go back to Omnicare and speak to them. But Judy Mencher, who was the advisor to the creditors committee, the informal creditors committee,
Yeah.
she got a copy of the Omnicare letter.
How'd she get
I don't
it?
know. Maybe Omnicare sent it to her. Maybe somebody in the company sent it to her. I don't know. But she went directly to Omnicare and said at the time, "This is never going to work. I mean, this is weak, and you can't expect them not to take
Right.
the Genesis proposal when your proposal is subject to due diligence. You've had a lot of due diligence about this company. You know what you need to know." The records show that at that point, Mr. Gumunder called a meeting of his council and his board, maybe, or his management anyway, and they considered whether or not they could drop this condition. And they decided not to, because they didn't want to take the risks.
Still, insistence on further due diligence was a precaution that Omnicare's board simply wasn't prepared to dispense with.
It's easy for me as a person that's done a number of transactions, M&A
Right.
deals, that I do this for a living, to say, we're going to get that information anyway, don't worry about it. It's a very different thing for a business person sitting on a board that they're fiduciaries. They take their fiduciary responsibility very seriously also. They wanted to make sure that they weren't stepping into something that an unknown. Now, they wouldn't have, but I understand their position.
Not surprisingly, Omnicare's litigation counsel recognized that its position would have been stronger if its bid hadn't had the diligence condition.
I would have probably been a little more sympathetic towards Omnicare if there had been something of a real limited conditional offer on
You
the
talking about
table.
due diligence? Yeah, I mean, I think that was certainly a problem. That was a weak point. And you can see both sides of the situation. For the target board for Omnicare to say, I want to do due diligence, I'm sure made them nervous. What if we abandon Genesis and Omnicare pulls out?
Right, right.
On the other hand, Omnicare had been precluded from doing any due diligence
True.
by reason of the exclusivity agreement, didn't know they needed to do it. So it's hardly fair to say that they should have bought a pig in a poke and given up their right to find out what was lurking. On the other hand, they had been around. They had made an offer to the creditors committee, so they must have had some level of confidence that they knew what they were buying. And I certainly would have liked to see them, from a litigation point of view, drop that condition when they came forward with that jumping bid.
Of course, NCS had its own litigation point of view to worry about. A worry that explained a decision that was surprising, given how tightly the NCS-Genesis deal was locked up. Despite a provision preventing NCS from dealing with other potential bidders, Genesis agreed to waive that prohibition and allow NCS to explore a potentially higher bid from Omnicare.
And by the way, the question you're getting at is one of the interesting, at least I found interesting in the situation is, within a month after we signed with NCS, we allowed them to talk to Omnicare without making the determination that the
It was a
offer
better offer.
could become superior or not. And looking back, I think there were a couple of reasons we did that, but I think a big part of it was I didn't think they were ever going to take the conditionality out.
Okay.
I thought they were just going to leave this conditionality there, and that was going to kind of screw up our deal in some way. And that was the reason NCS never wanted to declare it superior.
Right.
And I think NCS also felt like, look, the director, look, there is someone here offering more money. Like, the directors, they want to be able to talk to Omnicare to figure out, like, are you guys real or are you not, and what's really going on here? And we didn't want to put NCS in the situation of having to declare that superior when it wasn't really because of the conditionality, and so we allowed them to do it.
Whatever the reason, the Genesis decision to release NCS to talk to Omnicare certainly surprised Vice Chancellor Lamb, who questioned the wisdom of the move.
Did it surprise you that Genesis waived the restrictions in the merger agreement and allowed NCS to speak with Omnicare?
It did. I mean, I don't know. I can't remember when I learned that. I'm sure I didn't know it.
Wasn't till September.
I didn't know it in September. I don't think I knew that until November.
Yeah.
And yes, it did surprise me because
Why would they do
Omnicare's position was that they couldn't really go forward without due diligence.
Right.
The merger agreement had a provision in it that governed whether or not NCS could provide information to Omnicare. I believe the board of NCS met shortly after the merger agreement was signed, maybe the very beginning of August, and at a meeting concluded that because of the conditionality of the Omnicare offer, that it would not be able to exercise its right under the merger agreement to give them information. So they were in this position where they had this conditional offer and no way to satisfy the condition. It's where Genesis meant them to be when this structure was insisted upon by Genesis. And it's where the board understood things would be when they agreed to them, and where the shareholders understood it would be when they agreed to what they did. Why? I understand why Omnicare insisted, and I understand why NCS asked, because there was someone there who looked like they were willing to pay more money. So,
But Genesis at that point.
I mean, NCS had to ask, but then Genesis said yes, and I don't know why. I didn't know why at the time, and I don't know why now.
Yeah, I thought that was kind of odd too.
Other than that, they must have come to the conclusion that this was creating so much pressure, and that maybe there was a chance Omnicare would go away, and then instead it backfired.
Or thought that their deal was so tight.
Yeah, possibly. Although clearly, when it got to the preliminary injunction and then the appeal stage, Omnicare's case would have been much weaker if they did not have an actionable tender offer. If they still had this highly conditional proposal, then the Supreme Court would have been faced with the prospect of enjoining the deal that is certain and is going to have this insolvent company pay its creditors in full, and to enjoin that transaction in favor of a conditional, uncertain future. Actually, it was interesting. It would have put the court, me, and then the Supreme Court in the same position that the board of NCS was in July when it approved the merger. And I don't think I know I wouldn't have, and I don't think the Supreme Court either would have been insisted or been willing to force that risk onto the shareholders of NCS, because the whole thing could blow up. I mean, once the deal's enjoined, Genesis could walk away. Omnicare then drops back to a bankruptcy proposal.
That might have been just what Genesis was thinking.
Yeah, well, I don't know why Genesis would allow it.
They did. And in the midst of the litigation, Omnicare dropped the arguably problematic diligence condition to its bid for NCS. That development put NCS's counsel in an interesting position. Successfully defending the Genesis deal would result in the two largest stockholders, Alcott and Shaw, losing out on the millions of additional dollars offered by Omnicare's now unconditional bid.
I knew something was up the end of September because I was having a series of phone conferences with the parties about one thing or another.
Right.
And up until that point, Mr. Welsh, who was I think he was NCS counsel, or else he was representing Alcalta Shaw. I'm not sure, but he was on the NCS side.
He was on the NCS.
And he was very, very strong, as he always is. He's a great advocate, and he was very convinced and convincing about the position of the NCS board was taking. So by the end of September, the beginning of August, I started noticing his tone of voice was different, and that's when I guess they must have entered into discussions with Omnicare, and maybe I wasn't paying enough attention to tell you, but when Omnicare actually changed its tender offer and eliminated the conditionality,
October.
I don't know. October. So maybe it was just before that his tone of voice changed. So.
What a predicament he would have been in, given that, what do you do?
Well, he knew what the
know.
proper legal position was, but which was to defend what the board had done.
Of course.
But
A
he
deal's
also
a
knew
deal.
that the board, the shareholders, and Mr. Alcott and Mr. Shaw
Could get a lot.
were going to get more money. Now, I guess in the end, there was $100 and something million paid to the shareholders. And I think the initial proposals was more in the sort of $25 million
Yes.
range.
That additional payday wouldn't arrive, however, unless the courts derailed the apparently locked-up vote on the Genesis deal. And Omnicare had two basic arguments why the courts should do that. The first one asserted that under NCS's Certificate of Incorporation, the irrevocable commitment of Outcalt and Shaw to vote their shares in favor of the Genesis merger constituted a transfer of their shares to Genesis, resulting in a reduction in their voting power from 10 votes per share to 1 vote per share. The argument lost, but wasn't frivolous, and would have enabled the other stockholders to vote down the Genesis deal.
It was a fascinating issue. Mm-hmm. I don't have it front of mind, but it involved what I love the most, which is careful reading of charter language and trying to figure out how they apply in situations that probably you don't have any real basis to say or anybody had thought of at the time the thing happened. But the notion that by signing the voting agreement, Alcott and Shaw should have gone from high vote to low vote never made any sense to me. But there was traction to the other side. It wasn't like they had nothing to say. It wasn't a silly argument. It was a swing for the fences argument. It got.
Remember the in connection with proxy,
Oh, yeah.
and you're like, I remember my first reaction being, I don't follow
But
that.
you wonder sometimes why people raise certain arguments in cases. Mm-hmm. Was one of the purposes of Omnicare in raising that argument to sort of put greater pressure on the fiduciary point?
Why not?
I mean, were they saying, look, if you're not going to rule for us on the fiduciary point, you can still get the stockholders a better deal by just making a narrow decision based on this charter provision? Who knows?
But that first argument didn't prevail. And it turned out that Omnicare's second argument, that the lockups arranged with Genesis violated the NCS director's fiduciary duties, was one that Vice Chancellor Lamb decided Omnicare didn't even have standing to assert, because it never owned shares when the NCS directors approved the challenged transactions.
We had a kind of a very tight doctrinal kind of argument. Mm-hmm. Fiduciary duty issues should only be raised by people who were on the same page as the Sedicate trusts or whatever the English
Right.
words or something. The people were the beneficiaries of the fiduciary duty. Well, the bidder is the exact opposite. The bidder is the buyer. The buyer is a direct conflict with the seller. Mm-hmm. Why should the bidder be able to litigate fiduciary issues that are designed to benefit the selling stockholders? It didn't make a lot of sense to us. We never won that issue, and the way Delaware sort of, and not just Delaware, but other states have done the same thing, have sort of elided the issue, is to say, well, the bidder at least has to have the fig leaf of owning shares in the company
At the time.
at the time of the conduct complained of.
Of course, Omnicare's lack of standing didn't prevent stockholder plaintiffs from presenting the fiduciary duty claims, or prevent Omnicare from helping with that presentation.
What did you think of the whole standing argument? You're laughing. What did you
I'm not a litigator, so
Okay.
I'll let the litigators talk.
All right,
But,
we'll leave.
but it just struck me as, again, I was going to use the word silly. I shouldn't use the word silly when talking about a judgment of a vice chancellor. But clearly, there were cases that established standing for bidders. I don't know why they didn't follow through on that. We obviously had. It just made things a little more cumbersome. It's not like it really made a difference in the case because we worked through the shareholders and we were essentially writing the papers and then doing the thinking, and they were involved. Again, I don't want to denigrate the plaintiff's bar, but they clearly serve a purpose. But it's not like that decision was going to do anything other than just make it slightly more cumbersome.
In the end, Omnicare's biggest problem was the defendant's dogged insistence that the NCS directors and controlling stockholders had no sensible choice but to accept the Genesis bid, voting agreement lockups and all.
I view the case as one that, as I've probably said a few times here today, fundamentally about risk.
Right.
And I was asked by Justice Holland and at the argument about why the board didn't simply say no when it came to essentially locking up the deal.
Yes.
And ultimately the answer to that was that had they done that, the very risks that they talked about, they focused on, and they worried about, that stockholders ended up with nothing and creditors end up with less than they ended up with under the Genesis deal, could very easily come to pass.
Transactional counsel for Genesis saw the case as equally compelling.
So that really was kind of creative, putting all those pieces together in one.
You could say that, or frankly, another way to think about it, I mean, it was kind of just sitting there in front of us, right? We had these two shareholders who were also directors, but who were the ones who were both. They were the largest shareholders economically, though they did not, of course, have a majority. But
Right.
economically, they did have the largest economic stake, and they had the controlling vote. This company was in absolute extremis, and. Again, just from my experience in those other matters and then reading the cases, right, it was just like, I couldn't figure out why we couldn't do this. And you have business judgment on the part of the board, and then you have business judgment and shareholder action by the largest shareholders. And then you think about other things. Well, what would someone look at this and say, well, this is a problem? Well, one of the things we looked at, for example, okay, could anybody say that the other stockholders didn't really understand that they weren't going to get a vote on something like this? Well, the dual class voting and the high vote structure had been carried over from a predecessor company. There wasn't a single investor, no person had ever bought a share of stock with NCS at a time and without knowing that two people controlled the majority of the vote and could do whatever
Right.
however they want. They were protected against those controlling shareholders selling their stock for more, but this was a transaction in which the selling stockholder or the controlling stockholders had no conflict. They weren't getting different consideration
Correct.
or better consideration. They weren't continuing with there was like complete alignment of interest between them and the other stockholders.
And Vice Chancellor Lamb found that story compelling as well.
And the voting agreement, when you considered it in light of the whole, once you had the history in front of you and you understood the comings and goings of the
At
parties.
the time I decided that case, I probably didn't know everything. I certainly didn't know as much as I knew when I decided the preliminary injunction hearing, which was a few weeks later.
Right, and the voting agreement, though, once you had that background, wasn't problematical for you, was it? It made sense under the circumstances.
Do you mean as a deal, in
As a
connection
deal,
with the deal? And the,
right, as
Yeah,
a
of
deal
course.
provision,
Made perfect sense.
as did the irrevocable.
It made sense both from the point of view of Genesis wanting it,
Right,
and also from the point of, and insisting upon it, and the point of view of the company and its board and its majority voting shareholders in giving it, because they did it in order to secure the Genesis transaction, which, was the first transaction in a year and a half that had been proposed that would pay off all the creditors in full. It was going to be a merger, so even all the trade creditors would get paid. And there was a little bit of money for the stockholders. It was like $25 million for the stockholders. This was for a company which, at the time, was in default on its debt and was insolvent.
Well, like you said, there was a creditors committee trying to negotiate
The company was in
terms.
default. They had not been paying their $325 million worth of debt for a while. So the creditors had forborne from exercising their rights in default. And they had agreements with the company to do that, to extend the time, but it was clearly insolvent.
So when you declined to issue a preliminary injunction, and it seemed that you had a good board who made a rational decision under the circumstances. And then you look at the Supreme Court decision, and did you feel there was a lot of focus in that decision on what happened after the fact, after the board had to make a decision, as opposed to looking at where the board sat?
Sure. I mean, the focus is on the opportunity for shareholders to get a better price. And it came only after the fact,
Right.
because at the time the board made its decision, Omnicare had never offered the shareholder, had never made an unconditional offer to pay the shareholders anything.
By their own admission.
Until the end of
It
July,
says
they
it.
had never made any kind of offer
Right.
to pay the shareholders anything. The only thing they ever talked about was that Omnicare would buy NCS if NCS filed for bankruptcy, and they sold them the assets in bankruptcy.
So at that point, Omnicare's two main contentions were shot down in the Court of Chancery, and all it could appeal was the judgment on the certificate of incorporation transfer argument. The rejection of the breach of fiduciary duty claim was merely an interlocutory order, one that only the shareholder plaintiffs had standing to appeal. And the Delaware Supreme Court quickly declined to hear an interlocutory appeal on the fiduciary duty claim.
When we did seek an appeal, there was really only one issue that was going to be presented, originally at least, and that was the charter issue, because we had been rejected on a standing ground early on below. Our charter argument had been a loser on summary judgment, so we had an appeal as of right. The Supreme Court had declined to take the shareholders' interlocutory appeal.
But at that low point for Omnicare, things took an unusual turn.
So let's go back to that appeal, because you, as you said, what you thought the appeal was going to be versus what the appeal ended up being was a bit different.
It was a unique experience for me, and I suspect a lot of other people. After the preliminary injunction had been denied on fiduciary duty grounds, and we had lost the summary judgment opinion on the charter provision, we had an appeal as of right. Shareholders had an interlocutory appeal option, which they sought to pursue, but which was refused. So they didn't have an appeal. That part of the case was over. So we appeared in the Supreme Court little courtroom down here in Wilmington with the low ceilings. The chairs all full. People were interested in knowing how the deal was going to come out for the narrow argument about the charter. And I was supposed to argue that, and I'm sitting in my chair fidgeting. The worst part is waiting for the court to start. And they're late. And they're 5 minutes late, and they're 10 minutes late, and they're 15 minutes late. And we're trying to figure out what's going on. So Chief Justice Veazey, at that point, came through the door behind the bench without his robe on, by himself, and sat down and said, we just had a meeting in the back, And we've decided that we're going to reverse ourselves on the interlocutory appeal of shareholders' application, and we're going to hear that appeal. And we'd prefer to hear these two together, so we're not going to have an argument today, and we'll schedule something after they get their briefs in.
Right.
And my recollection is that they could have closed the deal between then and the time that we would have been heard, and the Chief Justice allowed us how he didn't want to have to TRO anybody in order to make sure they could hear the case. And unsurprisingly, the other side quickly agreed to wait, and so we scheduled another argument for, I'd say, a couple weeks, maybe later, so that this shareholder plaintiffs could brief their appeal. And that was in front of 3 justices. I think they've changed the process now so that most corporate cases are heard en banc in the first instance, but this was heard only by 3. And by the time I got home from that argument, I had a phone call that they wanted to do it en banc, in a few days, so we'd have to come back and...
You're like, yeah.
Yes.
I'm just not getting a break here.
Well,
I'm all
we were
prepared
still
once,
alive.
then you have to bring me back again,
Yeah,
now again.
The good news was we hadn't lost yet.
This
so.
is true. This was a high point. But what did you think when the Chief Justice comes walking in without his robe? I mean, I can't envision him doing that.
I never seen it before. I don't expect ever to see it again.
What do you think was going on?
Well, I think they did have a meeting, and I think when they read the briefs, they got a little more, even though it was on a different issue, they got a little more context about what had happened during the course of the process, perhaps more than they got out of the interlocutory appeal application. And they just changed their mind. I don't think they had made up their mind. In fact, I'm not sure. I can't tell you which 3 were on that original panel, but I doubt very much that they all voted in favor of us when the en banc came along. So I don't think it was an indication of how they felt about the merits. I think they just found it a much more interesting case than perhaps they had anticipated, and they wanted to hear it.
Well, maybe they were reading some of the facts
Maybe.
a little differently than others.
But I have to think, I don't think they get together regularly. I mean, I don't know what the process is at the Supreme Court level, but obviously that, given the expedited schedule we were dealing with, that was probably the first time they had all sat down and talked about it one way or the other. And somebody decided that there was enough merit to the shareholders' position here that it ought to be heard, and why not? We're going to have an argument anyway.
But at this point, it was still hard to tell which way the wind was blowing.
Great. So off you go and say, wonderful, I'll be back in a few weeks. So then what?
So then we had the argument in front of a 3-judge panel, and we were trying to figure out who was for us and who was against us. And I wish I could remember who was on. Well, you never can tell. You think you can tell, but I can't. I can't remember who was on that original panel, but Veazey was not. And I'm not sure if Steele was.
Wow, that's kind of interesting that they weren't there and they just said, okay, go ahead.
Anyway, so then, as I say, the argument was, they said, we understand the exigencies here. They knew that the transaction was awaiting closing, so they didn't want to take too long. And that's when we got the notice of the en banc. Obviously, they couldn't agree unanimously, so one of those 3, at a minimum, was voting a different way.
Right.
And so they brought back all 5. In a couple of days, we were back arguing in Dover. And then we started counting noses again, but we really couldn't tell who was going which way. It was really suspenseful.
The suspense quickly dissipated, but not before a surprising drama played out in the chambers of the Delaware Supreme Court.
My first reaction was, I thought that Vice Chancellor Lamb had written an opinion that I liked, admired, and was more than willing to follow. And I frankly thought he went one step beyond what he needed to do to decide it the way he did. If you recall the way the system worked at that time, we used the military system when we discussed cases, meaning
No, I didn't know that.
the junior officer speaks first
Okay.
and the senior officer speaks last. So the Chief Justice then, and I assume until the change in 2013, speaking last, always hoped it wasn't 2-2 when it got to him, right? Well, the biggest surprise I had was I stated my position, which was consistent with both what Chief Justice Veazey wrote and what I wrote in the dissent, and then I was stunned when there were 3 different opinions right after me. And it went to Chief Justice, and then the Chief Justice basically accepted in his own much more eloquent way the position that I agreed with. Not because I had
Right.
stated that position, but because he had the same view I had. There was no what I would colloquially refer to as a waffle period. It didn't exist. It was pretty clear in the first discussion that we had a 3-2 case. And nobody really was genuinely inclined to move away from the position they had taken. Although, as my entire, however many years it was on the court, I don't know, 13, whatever, it was a very respectful exchange of
course.
opinions. And
Of course.
it was just, we just couldn't come together on it, even though an effort was made to try to talk people into the majority view and even talk me out of writing a dissent at all. But I was
You just
pretty
couldn't.
fired up.
Yeah, you could.
I don't think I wrote a dissent and a separate dissent any other time in my
Interesting.
13 years.
The reversal, approved by a 3-2 majority, came out within hours after the en banc oral argument. The brief written order contained just one paragraph explaining why the NCS directors had breached their fiduciary duties. Even if one assumes that the board of directors attempted to seek a transaction that would yield the highest value reasonably available to the stockholders, the deal protection measures must be reasonable in relation to the threat and neither preclusive nor coercive. The action of the NCS board fails to meet those standards because by approving the voting agreements, the NCS board assured shareholder approval, and by agreeing to a provision requiring that the merger be presented to the shareholders, the directors irrevocably locked up the merger. In the absence of a fiduciary out clause, this mechanism precluded the directors from exercising their continuing fiduciary obligation to negotiate a sale of the company in the interest of the shareholders. Omnicare's lawyers still defend this reasoning, as fleshed out in the full written opinion that followed a few months later.
I've never really understood this negative reaction. Omnicare, to me, was just another in a series of cases. Phelps Dodge, Ace, QVC, Macmillan, go back to Anderson Clayton in the 80s. There's a series of cases that just say, look, there are a couple of bidders. You just can't block one of them out. You can't do that. And to me, that's what this case was all about.
Yeah, and the board has an ongoing duty to evaluate what's come. Now, that's not to say you can't put contractual restrictions on how the board deals with those jumping bids, but there's a limit, as I say. And to me, that's the most interesting thing about the decision from a precedential point of view. It focused, it applied in very clear terms the Unical standard to defensive provisions in a merger agreement. And to me, that was something of, it's not surprising as I sit back and think about it now, but typically everything is measured under Revlon. You were retarding the auction process if you put in a provision in your agreement that, restricted the board's ability to look at another bid.
Arrayed against these defenders of the Supreme Court's majority opinion was a chorus of criticisms from academia, the bench, and M&A practitioners, including the lawyers and judges we interviewed.
And I think that in business, certainty in contracting is extremely important. You can't plan without some evaluation from a cost-benefit analysis of the certainty of a deal that you've negotiated and what you believe at the time, honestly, to be in the best interest of the stockholders and the company going forward. I also was very suspicious that even at the very end, Omnicare still had a due diligence condition. And based upon the history, as I understood it, of the relationship between Genesis and Omnicare basically sitting back like a vulture, waiting to pick the bones of NCS, I fully understood why. I thought the directors did what they did. And I've never been a big fan of bright line rules. I think everything is contextual. And I thought it's a terrible thing for us to be put in a position where we're shaming these people who are unconflicted and who've worked very hard after facing the bondholders losing their money, stockholders getting nothing. They salvaged the debt substantially and they got something for the stockholders under a scenario where it didn't look like they were going to get anything.
Look, to me, none of this was really something that should be analyzed under the UNICAL standard of defensive mechanisms, because that was adopted to apply to actions taken unilaterally by a board of directors. And these actions were not taken unilaterally, certainly when you combine the voting agreement with the merger agreement, because in fact, you have a majority in voting power of the shareholders who are acting with the board to secure this transaction.
Whose interest is aligned
Their interests
with the duties
were
of the
aligned
board.
both to the creditors and to the other shareholders. And that's the point I think the Chief Justice makes and Justice Steele make in their dissents. But I didn't understand the basis for the Supreme Court opinion.
I have a lot of admiration for and appreciation of the justices who are willing to protect stockholders from defensive devices that are preclusive and coercive.
Okay.
And so I only reluctantly come to the conclusion of disagreeing with the court when the court is trying to do what it thinks is protective of stockholders, because I don't think that's ever an easy decision to make. And so I respect that. And if the discussion of the UNICAL doctrine in this decision had been directed to board-adopted defenses that had the effect of preventing the stockholders from making their own decision about whether to go forward with the transaction or not, I would say right on. I agree with almost everything you say. The problem was that what the court was addressing were board provisions designed to facilitate, implement, and effectuate a stockholder decision as to whether to go forward with the transaction or not. And I just didn't think UNICAL had any application to board conduct that facilitates a decision that the stockholders have made. I think the majority was genuinely motivated by a feeling that UNICAL was good law, that the preclusive coercive test was a good test, and I think it is in the context of things that preclude or coerce shareholder choice, and just lost sight of the fact that this wasn't precluding or coercing shareholder choice, it was facilitating shareholder choice.
But what was rattling about the opinion, and still rereading it today is rattling about the opinion, is sort of the point that Chief Justice Steele, subsequent Chief Justice Steele, hammered home in his concurring dissent, which was you've announced here a prescriptive rule.
Right.
There's something you simply can't do no matter what the circumstance, no matter what the context. And that was very un-Delawarean. And that's what made this opinion surprising, to some degree unnerving. And you just sort of wondered, when you get an opinion like this, that it's obviously very hard to predict how a court's going to view a set of facts. But this court viewed the set of facts the same way the Court of Chancery viewed the set of facts. It adopted the findings of the Court of Chancery.
Which was very, yes, you're right.
And yet announced a rule that certain things you just can't do. Well, that was startling. And it made people wonder for a while, well, what else are we going to find out we just can't do?
Well, I do believe the opinion is really all about risk. But I asked myself, okay, the risk was that Genesis might walk. Seemingly, the analysis is, still need a fiduciary out, too bad, which means you might have not have gotten the Genesis deal. If you didn't get the Genesis deal, you might not have gotten the Omnicare deal either, because based upon their track record, they were looking for an asset sale, 363 asset sale in bankruptcy. So that was a problem, but nevertheless, still had to have a fiduciary out. Had they not done what Genesis demanded, in essence, in order to get the high value for stockholders, the value of any sort from stockholders, because the stockholders weren't going to get anything, right? They had to go along with this. Now, if they hadn't done it, if they'd said to themselves, we got to have a fiduciary out,
Right.
what would have happened? What could have happened? Nobody knows. Nobody knows for sure. However, it's all about risk analysis. I think that's what the duty of care is about, in my judgment. That's right. And so the risk that they faced was Omnicare goes back into bankruptcy. They take the company back into the 363 bankruptcy proceeding, and potentially stockholders get nothing. I think, as I read the opinion of the Supreme Court, I think that doesn't matter. I think they have to always have to have a fiduciary out. That's how I read the opinion. I could be wrong about that. I'd like to be wrong about that, because I don't like to see that I might have to deal with it again.
So, if the majority's reasoning in the Omnicare case was unsupported by existing law, as one leading academic commentator said, what's the explanation for the rift on the court? To begin with, there's a somewhat cynical explanation.
You could chalk it up to hard cases make hard law. That's what I think happened here. Very tough for a court. When a court knows that by signing an order, stockholders will get more money, that's a huge amount of pressure. Huge amount of pressure. I'm not so cynical as to say a higher bid will always flush away everything that came before it. But if I was a judge and someone saying, look, the stockholder's going to get 50% or 30% or 20% more value if you sign this order striking down these defenses,
Yeah.
not an easy call.
One more principled explanation might have focused on the fact that although they owned a majority of the voting power, the stockholders whose voting agreements locked up the Genesis deal had an economic stake that was a much smaller and minority percentage.
What they were, I think, wrong about in the Omnicare case was that we had gotten the stockholder approval. Now, if they had wanted to say, if they would wanted to have a narrower rule, and this occurred to us, if they had wanted to say that here the stockholder vote shouldn't lock up the deal, shouldn't be permitted to lock up the deal because it was supermajority vote, and the 60% that voted was actually only, I think, 20 or 30% of the equity of the deal. So because there was a supermajority class of stock, super voting stock class, what was really a minority part of the equity of the company could dictate to the majority of the equity of the company, we're going to do this deal. Now, you can say, well, that's exactly what people bargain for when they invest in a company that's got class votes.
Right. You're giving veto rights.
Yeah, but it's an equity that would have resulted in a narrower decision than the one that was entered here, because this one didn't turn on the fact that it was supermajority voting stock and it wasn't a majority of the equity.
Another possible explanation was that the Supreme Court really didn't believe that Genesis' threat to walk away was real, or that the law should give target boards the ability to tell bidders like Genesis that the lockups they're looking for are just contrary to law.
How about the fact that Genesis truly, basically gave NCS practically no time to make a decision, basically said, look, take it or leave it. Or, there was a risk, wasn't there, if NCS did not accept Genesis? They weren't sure about you at that time when they were making the decision.
Putting the best light on it from their perspective, the answer to that is sure, yes, I get that. But I guess I would point out a couple things.
Sure.
One, I've never seen an ultimatum, I've been doing this for close to 45 years, that someone really followed through on. Now, maybe they really were going to, maybe they really were not going to put themselves in a position where they were going to have Omnicare come in, but I think there's at least some obligation to test that notion.
I think a charitable way to look at this is that the justices simply, they didn't believe, two ways. Either they didn't believe the ultimatum, and they're second-guessing NCS for believing the ultimatum, or you could say they looked at the situation and they just said, boy, wouldn't it have been better if Genesis couldn't have made this demand? What if we just took this out of the arsenal altogether? Mm-hmm. I bet, and I think they're substituting their judgment. I think they were saying, I bet that if the rules of the game had been that you couldn't lock up this deal, I bet Genesis would have done the deal anyway.
As someone
Yes.
on the Supreme Court said in the Omnicare argument, this is the third rail. A target board is able to resist, even in circumstances in which this board found itself, resist the entreaties of an acquirer by saying, the law doesn't let me, I'd love to, but the law doesn't let me do that, and so you're going to have to play on our field. And I suspect that was part of the considerations when the policy was brought up.
Another possible explanation. Maybe the Supreme Court majority was just skeptical that the interests of the two key stockholders, Outcalt and Shaw, were really perfectly aligned with the interests of the stockholders of NCS generally. If those two stockholders had any competing self-interests, one of the dissenting justices acknowledged that the case would have been very different.
I've always been wary of hindsight review unless somebody has clearly acted in their own interest while serving as a fiduciary at the expense of the beneficiary of the fiduciary relationship. If the facts are clear that that's what's happened, I wouldn't have any problem coming down hard on them.
Sure.
And enforcing as strictly as the facts demanded, whatever the consequences proximately caused by that breach of fiduciary duty.
True. The majority opinion didn't rely on any such conflict of interest, and both Vice Chancellor Lamb and Justice Steele noted in their opinions that Outcalt and Shaw were aligned in interest with the stockholders.
The Supreme Court opinion spoke about the duty of the board to protect the minority shareholders. And that's a line of thought that comes into play where there is a majority, and here there is a majority, but a majority that's acting with a self-interest. And it was certainly a major focus of mine to understand in this case whether Mr. Outcalt and Mr. Shaw had any kind of sort of disabling self-interest in this deal. If they did, it would have been a very different deal. But they didn't. They really just didn't have any conflicting interest.
But some have suggested that Outcalt and Shaw weren't in fact totally disinterested.
Did you think that the director shareholders that gave the proxy and entered into the voting agreement, did you think their interests were aligned with the minority shareholders? Everybody wanted to get money, and
come out a winner.
Everybody always likes money. Outcall had a consulting agreement, and the vice chancellor minimizes that, or one of the opinions minimizes that. But again, that's money. They say, well, it wasn't enough relative to his net worth or what he was getting in the deal to make a difference. But it's something he got that other shareholders didn't get,
But it wasn't significant.
it's not significant. But if you sort of put it in the context of an all holders best price world, and I understand that's tender offer, and you then have to consider whether that's really consideration for his shares or is
Sure.
that consideration for other things. But he got more than other shareholders. With respect to Shaw, it's very clear he was not going to be an employee of Omnicare. Although I think that Joel at some point after the fact may have said, we'll consider continuing employment, but he wasn't going to be CEO of a public company anymore. That was for sure. There was obviously no written agreements with Genesis, but Genesis had some senior leadership vacancies. So
Sure, it's consideration.
I'm sure that was, he's human, that probably entered into his thinking. I don't know if there were any conversations on that point or not. So there was a possibility of employment there. There was no possibility of employment for him at Omnicare.
So why do you think the board would agree to all of Genesis demands?
Well, that's certainly an explanation, whether it was a part of the case, a big part of the case or not. That was it Outcall or Shaw? I think it was
I don't remember.
Outcall.
I'm bad with
was
names.
going to be the combined companies
CEO.
CEO. That would certainly explain their willingness to lock it up. And the conflict that they had with the rest of the stockholders who didn't have a vested interest in this particular transaction, regardless of the prospects for more consideration.
Finally, the Supreme Court's majority decision, if not the reasoning, might have stemmed from doubts about the factual account in Vice Chancellor Lamb's opinion. The shadow story is one in which the directors and principal stockholders of NCS, for selfish or arbitrary reasons, preferred not to deal with Omnicare and missed or intentionally avoided opportunities to elicit a higher bid from Omnicare.
And I would note, when we talk about the
Please.
facts, if you look at the Supreme Court decision, which I actually reread in preparation for this, the decision rests on a unical analysis, and they assume the facts. But in my rereading of it, there's a certain skepticism in the facts. I mean, the Supreme Court says, look, we're going to assume these facts, but among the facts we're going to assume, and the fact that they discharged their fiduciary duty, we're going to assume that it was all okay, notwithstanding the fact that they signed an exclusivity agreement, they acceded to all of the demands of Genesis, they abandoned their stalking horse plan. You could look to me, what the Supreme Court seems to be saying is, I'm not so sure about these facts. I mean, there may be a different way of looking at these facts. And then they go on to say, and by the way, given the fact that they were improving and that they were no longer really on the verge of bankruptcy because they were getting value for the equity and they were convincing at least one buyer to pay for the equity, that why wouldn't you at that point have reached out? That's really kind of an aside in the case because they're focusing on the unical analysis. But I think there was some skepticism, at least in the majority, as to, in looking at those facts. Yes, you could look at it and say, well, gee, Omnicare was this big bad person and they just wanted to buy it in bankruptcy and they made this bankruptcy bid and then, oh, gee, all of a sudden, 6 months later, they reappear with a conditional offer. A skeptic might look at that and say, well, gee, what happened in the interim and why exactly didn't you attempt to contact them in the interim? Why didn't you attempt to re-engage them? I read a little of that into the decision.
Wouldn't you think it's possible that based on the Genesis presentation and the reputation of its counsel that NCS might have thought, reasonably might have believed that the ultimatum was for real?
And again, putting the best face on it, let's
Yes.
assume that it was. That ignores the fact that for 3 or 4 or 5 months before they got that ultimatum, they did nothing to reach out to Omnicare. The other thing that ignores in kind of the real world of M&A, in my view, is, the facts that weekend were somewhat humorous in a way, but Mencher contacts Joel and says, you got to put a bid in, you got to put a bid in. So we contact all these people and nobody's responding. Now, it's unclear to me time-wise when exactly that exclusivity agreement ended, but it was a Friday. It got extended that day. And I'm not sure whether it got extended before we started reaching out to them or afterwards.
You never found that out.
No, and the only way we got to them is my brother had an office in the same building as the NCS people. So it was a Friday afternoon. We got his secretary to come back in the office, and we faxed the thing to her and told her, please don't read it, and put it in an envelope,
Right,
put it under the door. So that's the way we got the offer to them. NCS could have come to us and said, you know what, let's talk. Instead, what they did was they signed an extension of the confidentiality, the exclusivity agreement, and said, oh, gee, we can't talk. I get it. I get what Genesis wanted, and I suspect that the senior management knew there was no job for them at Omnicare. I don't know if there was any discussion of that with Genesis, but clearly they were done if Omnicare bought them. But I've never really understood this negative reaction to Omnicare. To me, it was just another in a series of cases. Phelps Dodge, Ace, QVC, Macmillan, go back to Anderson Clayton in the 80s. There's a series of cases that just say, look, there are a couple of bidders. You just can't block one of them out. You can't do that. And to me, that's what this case was all about.
To lawyers on both sides of the case, Omnicare also resolved one unsettled aspect of Delaware M&A jurisprudence.
I think Omnicare was actually the first case that made it clear that defensive measures in a sale were going to be viewed with enhanced scrutiny under Unical.
To me, that's the most interesting thing about the decision from a precedential point of view. It focused, it applied in very clear terms the Unical standard to defensive provisions in a merger agreement.
But there remains a basic awkward question about what the Omnicare case actually accomplished. Because ordinarily, if the board approves a merger and the holders of a majority of the votes want the deal to go forward, they can sign written consents and the deal can occur right away, at least as a matter of Delaware law. Indeed, that may partly explain why the facts of Omnicare have never been repeated and why the case has never been overruled.
Well, I think maybe the only reason that precedent has survived is because it just really comes up so rarely. You almost, like we've talked about, in any public deal, you can't get a shareholder voting agreement. It's just not practical. Right. And in any situation where you can get a shareholder voting agreement, you can get the consents and execute them right after you sign the merger agreement, and you've got the same result.
Well, what do you think the lessons were from this case, besides an affirmation of prior decisions and keeping order and reliability in our law?
Well, I suppose one lesson is that an opinion can develop a bad reputation even before it's issued. Because this one certainly did. I don't know how often Omnicare's been cited since it was decided, but it became almost a meme, like a mantra, the word Omnicare, people said, "Oh, well, that's just a crazy decision." I remember being at, as I said, Tulane. Did I mention that
Yeah, got a
Rob
spot
Kindler?
on it,
No,
yeah.
I think it's Rob Kindler came out with a bag over his head because he had been criticized about railing against the outcome before the opinion had even been rendered. But I think it stuck. I think people, for one reason or another, think it's a one-off aberration. In a sense, it is, because I don't think you're going to see a situation where you have an open period between director approval and stockholder approval. That's absolutely locked up. If you have those agreements, you're going to consent to them right after the time the merger agreement is signed, and the deal is going to be over. You're not going to have a period where the board has to re-examine its recommendation to sign that document. So that's going to be a very odd, and this was a very odd situation, very odd.
A very odd situation indeed, where the precedent set by the majority opinion in Omnicare seems like a one-off.
The word got out right away once we had these opinions, and then you had comments at CLE programs of people saying Omnicare will have the life of a fruit fly, it'll never happen again. I get calls from either my corporate partners or other people saying, well, we want to do this transaction and we want to do A, B, and C. And it was exactly like Omnicare. And I said, well, that's Omnicare. Can't do that. I said, what do you mean you can't do that? That decision
Look at the dissent.
Yeah, that decision's not right. I said, well, it may not be right, but if you're going to have to litigate this in the first instance in the Delaware Court of Chancery, what's the Delaware Court of Chancery supposed to say? That the majority opinion is not the law of Delaware?
Can't.
And you look for ways around it. People look for things like acting by written consent. And there was it was a bench ruling that said, yeah, that's different. That's pretty hard to understand, particularly if there was a contract obligating the person to act by written consent shortly afterwards.
So the Omnicare case remains sort of a ghost precedent, and Vice Chancellor Lamb recounts an appropriate epitaph for the case.
So is there anything else you want to leave us with that, we wouldn't necessarily pick up from reading all the filings?
Let me just say that some years later, and I think this was after I no longer was serving as a judge, there was a program put on at the University of Pennsylvania to discuss the case, and either Mr. Outcalt or Mr. Shaw or both were there.
Interesting.
And I remember them coming, one of them at least, and because I think only one was there,
Right.
coming up to me and telling me he thought I had done the right thing.
Oh, well, that's always nice. That's always a nice way to end it.
Exactly, right. Even though he made lots more money with the way the deal came out.